In this lesson, we're going to move away from looking at the theological influences of natural law theory, looking at people like Augustine and Aquinas within the sort of early Middle Ages and the High Middle Ages, and we're going to start to talk about how natural law exists in today's jurisprudential conversations, whether or not natural law still does exist, and what the modern theories of natural law actually are. So far, our study of the natural law tradition within the sort of broader philosophy of law has gone from looking at the historical developments, beginning with the ancient world of Plato and Aristotle, and then talking about how Plato and Aristotle were influential on the religious influencers, people like Augustine and Aquinas. This lesson, we're going to talk briefly about the impact of these classical theories before turning to look at an introduction at more modern natural law theories. And we will then spend the final two lessons on natural law looking at those two theories in more detail. So we have spent a lot of time and a few weeks exploring classical natural law. We've been talking about the way in which it is elucidated through the ancient thinkers of Plato and Aristotle, at least influenced with a limited amount of hinting, essentially, with Plato not placing too much emphasis on the importance of law, and Aristotle placing a little bit more emphasis on the importance of the law, specifically within the idea of the nature of the human condition. But it's only really where we see the early church fathers and the sort of high Middle Ages with St. Augustine and St. Thomas Aquinas that we start to see the true elucidation of what we would understand natural law theory to be to this day. It's for that reason that many people, when studying natural law, probably don't think that much about Plato and Aristotle, even though in reality those were the two influential Greek philosophers that really had such an impact on the way in which Catholic doctrine and religious doctrine in the medieval period actually operated, and things like scholasticism as a movement and the sort of the rediscovery of the classical world. We've seen these theories situate themselves within the broader question of ontology, talking about the ontology of law more generally, i.e., what is law itself? What actually is it to call something law? What does that actually mean? When we talk about law, why do we describe some things as law and some things as not law? And one of the issues that was had by these classical natural law theories is whether or not it is sufficient in proving more substantive analyses behind some of the critical issues within jurisprudence. So the question that was asked, and the question that seems to be most pertinent for those of the classical natural law theorists, is what makes something law? With the religious influences, they argued that it was adherence to some higher authority, some eternal rule, such as the law that is created by God, or some kind of adherence to a higher objective morality, i.e. biblical morality, or some kind of natural law that is more of a moral theory rather than just a theory of law. But these are questions of ontology. These are questions that are essentially asking what are the things that if we have a set of all things that are called law, what does it require for something to be a part of that set, essentially? So the more substantive issues, like the process of lawmaking, the administration of law, the concepts of justice, aren't necessarily as influential in these classical theories of natural law. And so as a result of which, we think about the impact of these classical theories. These are theories which are impactful on the basis of their ontological influences over law. But the concept of procedural lawmaking and the concept of administration of law and the concept of justice are things that we're going to have to think about when we look to the modern theories of natural law. Now, the thing about modern natural law is that for the longest of time, it was relatively niche as a movement, owing to the growing importance and the growing popularity of legal positivism. And so there are various social, cultural, and philosophical reasons why the interrelation between law and morality became less and less popular during the sort of Enlightenment period, and even in today's understanding of jurisprudence to an extent. However, certain things that takes place that takes place in the early 20th century actually brings back this question of law and morality, and things like, for example, the atrocities that took place in Eastern Europe in the 1920s and the 1930s with the Soviet Union and Nazi Germany gave this question of law and morality and the reconciliation between the two more and more importance. So more and more people were asking questions as to how is it the case that law has been able to allow for things like war and genocide to take place in such a flagrant and brutal way. So the development of law in this case surely should bring with it reference to morality, owing to the fact that under legal systems that existed in the Western world, at least within Germany, things like genocide was able to take place and dictatorship was able to grow and fester. Now, while legal positivism doesn't necessarily avoid or refuse to talk about the conceptualizations of law in relation to the concept of morality, within the traditional legal definition at least, it does relegate issues pertaining to morality to the periphery of the core concepts within legal jurisprudence. So, whereas natural law takes moral philosophy and makes it a central thesis within its general theories of jurisprudence, legal positivism takes moral philosophy and leaves it to the peripheries. And as a result of this, the resurgence of more modern forms of natural law begin to increase in popularity, owing to the clear moral questions that had to be asked at the end of the Second World War, and continue to be asked even to this day. So with all of this context given, let's think about what the two modern natural law theories that we're going to focus on in the next two lessons are. We're going to talk about procedural natural law, a theory which was developed by philosopher Lionel Fuller, and then we will also talk about a theory of natural rights, which is a development theory which is developed by Finnis. So Fuller and Finnis are arguably the two most prominent modern natural law theorists, and we'll talk about what procedural natural law is in the next lesson, and then we'll talk about what the theory of natural rights entails in the lesson after. Welcome back everybody to our studies of jurisprudence. We are continuing talking about natural law in this lesson, focusing on the first of our modern conceptions of natural law, sometimes described as procedural natural law. The idea of examining natural law, examining a theory of law through the lens of procedural elements, essentially. Now, it's going to be an examination of the natural law theory, which is advanced by Lionel Fuller, and this is this idea known as procedural natural law, or sometimes described as procedural naturalism. Now, essentially, we would see this idea of legal naturalism and procedural naturalism develop over time on a basis of an analysis which he believed to be a weakness of the way the law operates. So he looked at the way the law operates and looked at the way we analyze the law from a philosophical perspective, and takes the view that this is quite a weak position to stand from, especially with reference to legal systems and law itself that actually led to situations where heinous crimes and clearly immoral acts are committed. So, for example, the Third Reich and the rise of the Nazis to power in Germany, the fact that this was done essentially through legal means, and essentially they were able to instigate genocide through a legal system, or at least they utilized the legal system in many different ways. So given the fact that you have the operation of law against that of quite significant human rights and moral violations, the idea of legal naturalism kind of spawns out of this idea. The question of whether or not the Third Reich was governed by law and the rule of law is actually a controversial question, especially for those positivists who seem to suggest that morality should exist on the periphery of legal debate, and the Third Reich's legal system was something of an interesting thing that people study within history. But Fuller himself, while debating this issue with a legal positivist, the positivist of H.L.A. Hart, essentially was trying to make a broader point, not necessarily about the concept of law specifically relating to the Third Reich, but talking more about a broader concept relating to the nature of law, and specifically the nature of legal procedure. And this is quite interesting because one of the things that we noted from previous lessons when we looked at natural law was this idea that natural law seems to, at least in the historical perspective, when we look at people like Augustine and Aquinas, natural law appears to look more at ontological questions relating to law, i.e. what law actually is and what law isn't, and what it means to call something law. And you obviously get the famous adage that an unjust law is not a law, etc., etc. Now, what Fuller likes to do is take a more natural law approach to the concept of legal procedure. And this is where we get procedural naturalism. And essentially, the idea of the procedural natural law, as I mentioned, comes out of a debate between Fuller, the natural law advocate, and Hart, who is, of course, a legal positivist. And what happens is we see a rejection of this legal positivist view that there is no necessary connection between law and morality. So in the previous lesson, if you remember, we mentioned quite briefly that natural law sort of takes a bit of a beating in the sort of modern jurisprudential theories because of the growth in the popularity of positivism. And while positivism doesn't suggest that morality plays no role at all in having any kind of philosophical discussion about law, there isn't this necessary connection per se like there is when we talk about natural law. Fuller argued that at the foundation of the legal system there existed certain moral principles and standards, and he called these principles the principles of legality. And it's these principles of legality that form the foundation, the bedrock for a legal system, and that these are the principles which do contain with them moral standards. One of the things that should be noted is that while Fuller accepts that morality and law are inherently interconnected, he doesn't go so far as to accept the sort of church father Augustinian or Aquinas religious conception of natural law. So he will make the argument that there is an inherent connection between law and morality, but he doesn't go so far as to suggest that the idea of morality and the concept of the natural law from this sort of abstracted sense is necessarily something of a religious doctrine and something that requires religion or a belief in religion. So, for example, when we talk about the ontology of law, if we remember back to people like Augustine and Aquinas, there was this reference to and the grounding of the ontology of law in some kind of higher authority, like the eternal law of God. This is something that is not believed by Fuller and is rejected by Fuller. And so this is really where we see the sort of modernization of natural law theory in this regard. So if that's the kinds of things that natural law, or at least the procedural natural law, doesn't do, what does procedural naturalism actually tell us? Well, it suggests that there is an inner system of morality which is actually built into not only the labeling of what law is and what law isn't, i.e. the ontology, but actually the structure and the administration and, as you may suggest, the procedure of the law. Essentially what this means is there is the imposition of a minimum standard of morality for which law ought to adhere to. And so in a similar way that, according to Aquinas and Augustine, you could judge what a law is and what a law isn't on the basis of whether or not it is coherent and related to and can exist in conjunction with the eternal law of God, Fuller makes a similar argument to an extent by making this point that there is a minimum standard of morality for which the law ought to adhere to in order for it to be law, and that this is built into the structure and the administration of law itself. Where a law is considered to be evil, and so clearly in violation of some foundational moral principle, it can be said that those laws are not law. It can be rejected as being law itself. In his arguably his magnum opus, Morality of Law, what Fuller invites us to do is engage in a hypothetical scenario. And in this hypothetical scenario, we see a hereditary monarch. We have a state that is attempting to be ruled by a hereditary monarch called Rex, or Ray. The issue is that this monarch is particularly incompetent, and that this endeavour to try and be able to rule as a hereditary monarch, there are plenty of hereditary monarchs that could probably fit into that category. And in order, he had succeeded the dynasty, had he succeeded a dynasty which had a particularly poor record when it comes to procedural lawmaking process, we see a problem here because, of course, not only is he particularly incompetent, but he's trying to inherit a dynasty which is also particularly incompetent. Now, what Fuller argues is that this monarch would be unable to make law in a meaningful way because he will fail to meet the prerequisite criteria for lawmaking. And so this is how he tries to hypothesize the ways in which the creation of law takes place. And instead, what Fuller does is he uses this example, he uses this thought experiment, and he talks about 8 conditions which ought to be met in order for the proposed law to be considered law. Okay? Now, these criteria for lawmaking are explained in the negative. So rather than explaining the 8 criteria for what makes law, he talks about the ways in which an individual can fail to make law. And the reason why he does this is because he is doing this through the lens of the hypothetical thought experiment of the hypothetical monarch. And he's talking about a monarch that is failing to be able to create law. And so as a result of which, why can he fail? Why will he never be able to make law? Well, these are the reasons. And so that's why he sort of defines it in the negative rather than in the positive. The first of these criteria is just to fail to establish rules at all. Failing to make those rules public, and so as a result of which the individuals who are supposed to follow the law, the rules themselves, are unable to be able to even know what those rules are because they are not able to see or be able to understand what those rules are. A failure to make the law prospective. So where there is law which is retrospective, we argue that this is not law, according to a procedural natural law theorist, because it would violate some of the foundational administrative principles of law. Failure to make the law clear and intelligible. If the law is unclear, if it is vague, and it is impossible to understand, shall we say, then these are all criteria that suggest that law cannot exist in that regard. Failure to make rules which are free of contradictions. You shouldn't be able to have a law that exists that has within it contradictions. So you can't have a law that simultaneously tells you to do one thing while also doing the opposite. And therefore, you're basically damned if you do, you're damned if you don't in that regard, because that is an unjust and immoral way in which you can create law. Failure to make rules which are possible to comply with. So an idea here is that an impossible law is not a law. A law that requires legally an individual to do something that is impossible to perform, then that cannot be a law either. The penultimate one is failure to allow for constancy of rulemaking, consistency when it comes to rulemaking, making rules in a way which is not arbitrary and is not going to essentially be difficult to understand. It all fits into these sort of general rule of law principles. And then finally, you have a discontinuity between the rules as stated and the administration of those rules in practice. So Fuller likes to make a delineation not only between the law as it exists, so the sort of black letter law as we can describe or we could read in the legislation, but also the administration of that law as well. There has to be a continuity between the rules that are stated and the administration in practice. So essentially, the purpose of these criteria, as Fuller argues, is to subject human conduct to the governance of rules. This is what is said in Morality of Law. And then, as a result of which, Fuller suggests that there may be a lacking in one of the 8 rules, or where there may be lacking in one or more of the 8 rules, the system in question fails to be considered a legal system. So it strikes at the heart of not only the ontological question of what makes law, but what makes a legal system a legal system. Welcome back everybody to our lessons on jurisprudence. This is the final lesson looking at natural law theories. We're going to talk about the argument in relation to the theory of natural rights in this lesson, which is the second of our modern natural law theories. The previous lesson we looked at procedural natural law, or the argument that is presented by Fuller, which is this idea of procedural naturalism, a theory, and we unpacked the hypothetical thought experiment that was derived out of Fuller's arguments, and we talked about the various criteria that Fuller believes are the stumbling blocks, if you will, for where law fails to be created. This lesson is going to talk about the natural law approach, which is presented by Finnis. This is this idea known as the theory of natural rights. Now, we see a significant differentiation between Fuller and Finnis in terms of their theories of natural law, which just goes to show that even though we are talking about modern conceptions of a fundamental theory of law, we are talking about very, very different ways of approaching it and very, very different ways of conceptualizing these different theories. So, let's just talk about some of the ideas and the derivation of the theory of natural rights briefly. So Finnis presents the view of the theory of natural rights in his work, The Philosophy of Law. And this is sort of born out of and derived out of the concept of morality, as you would probably understand, owing to the fact that we are talking about natural law theories. It is said that law occupies the same place in the world as morality, what I should do and what type of person I should be. This is what Finnis says on page 42 of his Philosophy of Law. He is talking about the fact that even though we can probably codify and outline some major differences between law and morality, they occupy the same place in the world. They occupy the same plane of existence. And so, to Finnis, this is the most central and important part of his philosophy of law, the idea of the interrelationship and the conceptualization of law and morality. This is so central to his work, and it is also so central to the inner understanding of Finnis's ideas, that the improvement of law ought to be understood on the basis of a conformity to morality. Again, this shouldn't be too controversial or too wild a claim and an argument, given the fact that we know already that natural law theories have quite a consistent interlinking and interrelationship between the concept of law and the concept of morality. But this is far from a theory, far from the theory that is the theory of natural rights, which Finnis ultimately tries to argue for. In fact, the theory of natural rights is more of a theory which pertains to the specifics of individual laws and individual rules. Again, we are not talking necessarily about broader and all-encompassing conceptions of natural law as defined by, for example, Augustine and Aquinas. We're talking more about the specificities of law, and this is what modern natural law seems to be doing, and the kind of direction that modern natural law seems to be going in. It's talking less about broad conceptions of what law is and what law isn't, and also talking about the concept of procedure, the concept of administration of law, concept of individual rules and individual laws themselves. So what essentially Finnis argues for is the idea of a golden rule, and this is the principle that law ought to be instigated as a whole for the purpose of promoting basic moral goods. This is taking his theory of natural law away from broadly descriptive claims about the ontology of law, and actually starting to talk about normative claims about law, talking about the idea that law ought to be instigated for the purpose of promoting basic moral goods. So we're talking about not just whether or not a law is unjust or immoral, but if the system of law as a whole pertains to this golden rule, then there may be room for the justification of such principles, and that it is the striving for the linking between the law and the golden rule, which is what his theory of natural rights entails. It entails a belief in the normative claims of what law ought to be. Now, just like with classical natural law scholars before him, so people like Augustine and Aquinas, who of course were influenced by the likes of Plato and Aristotle, what Finnis does is present a theory of law which is also applicable to broader moral philosophy. Remember, natural law and natural law theory isn't just a theory that is specifically jurisprudential. It is not just a theory of jurisprudence. It is a theory of moral philosophy more broadly. You can, if you study normative ethics, especially if you are somebody who has studied normative ethics at A level or potentially gone to university and studied philosophy, you might do a module on normative ethics. Natural law theory is one of the foundational principles of moral philosophy. It is up there with the deontological theories of Kant and the consequentialist utilitarianism of people like Bentham and Mill, and even the sort of virtue ethicists such as that of Aristotle. Now, according to Finnis, law ought to facilitate the common good. It does so through the provision of rules which can solve problems of coordination. And if we look here at this quotation from Finnis, it says here that the term law, the question of what law is, primarily to rules made in accordance with regulative legal rules by a determinate and effective authority for a complete community and buttressed by sanctions in accordance with the rule-guided stipulations of adjudicative institutions. This ensemble of rules and institutions being directed to reasonably resolving any of the community's coordination problems for the good of that community. This is a summarization of what Finnis believes to be his definition of law and the theory of law in a relatively concise manner. He's talking about community coordination, so the idea of essentially operating a societal structure, and that's what law ought to do, but they're doing it for a particular purpose. So you are solving community coordination problems, but for a reason, and that reason is for the common good of that community. Finnis suggests again, from a normative perspective, that there ought to be tests in place to express the elucidation of the natural law method from first principles, from the foundations on which natural law is built. It is argued that the test for practical reason ought to be viewed in conjunction with what he calls the basic goods, and that this combination of the two will represent a foundational bedrock structure of his natural law theory. So his natural law theory is more than just the basic goods. It is also the test for practical reason. And then finally we get this idea of the natural rights approach, which is presented by Finnis and is one which is very important and impactful in the broader sense of jurisprudential thought. It is one theory which, while having hints to these sort of Thomist approaches of Aquinas, you have clearly separating the positions of natural law into the positions itself and the positions of natural law into their broader conversation. And so as a result of which you still see hints and influences of the classical theorists, of people like Aquinas, in the more modern natural law theories, specifically this theory here presented by Finnis of natural rights.